Appreciate it. Now for our last case of the day. Is it ANNEXY or ANNEXY versus City of Tarpon Springs?
Good morning, Your Honors. My name is Daniel Rock, and I represent the plaintiffs, Mary ANNEXY and ANNEXY Group, LLC. I would like to reserve 5 minutes for rebuttal. Your Honor, I'm going to proceed a little bit differently than the brief is presented because, to me, the most obvious reason to reverse this case was for the abuse of discretion by the trial court. One could certainly say it's even a gross abuse of discretion.
Well, let me just stop you there, because you can correct me if I'm wrong. I've been wrong before, and I'm humble enough to let you do that. But as I read this transcript, you appeared below to a motion for summary judgment hearing, correct?
For my motion for summary judgment.
I understand that,
yes.
Yours. But the judge heard yours too.
Yes.
He heard them both, correct?
Yes.
And not one time did you ever tell that judge that you weren't ready, that you never got a copy of theirs, that you were prejudiced, that you intended to file anything in response thereof, did you?
Yes, Your Honor.
Where is it in the record, sir? Because I cannot find it.
I think there's one point, if I remember correctly, and
I
I could be wrong as well. I think you mentioned that you hadn't seen it.
That's correct. I hadn't even...
You didn't request a continuance on that. And
Prob-
you didn't say, I would file some other stuff.
I really wasn't in a position to argue for it or against it because I hadn't seen it.
Yeah, but it's so easy to get one continued, because you could simply argue to the judge, we're not done with discovery, we have a deposition scheduled, my interrogatories haven't been answered, this and that. And it's so easy. Plus, those are reversed every day when a judge denies that.
Your Honor, I was shocked to find out that there had been a hearing set.
But let me ask you this. You were shocked, but not because you weren't given notice. You was shocked, you admit, or you acknowledge, because of an internal, deviation from norm in your office.
Your Honor,
That's what caused the whole problem.
yes, Your Honor. The attorney, the secretary who allowed the hearing to be set, even sent it out under my electronic name, indicating that I had no problem with the time. And I didn't have a problem with the time when she called me on the intercom and said, do you have a problem with your hearing being set at such and such a time? And I said, no.
Right.
Well,
You just never knew that it was for both motions.
Yes, Your Honor, because
I understand that.
Because
and I suppose, like you submitted a supplemental authority, and in that case, the judge just, the attorney didn't show at the hearing, and the judge just proceeded to grant the other parties relief with it. That's not what happened here. The judge heard the arguments, but one thing that's not explicitly stated in that case, but that is a component of motions for relief because of excusable neglect, is that you have a meritorious position. And didn't the judge hear, and in the case you submitted, in fact, our court reversed on the merits because, impliedly that was one of, there was a meritorious position by the party who lost out owing to the glitch. Here the judge said in the motion, in the hearing on the motion to set it aside or to reconsider, what would you have argued? What is your position? And you didn't really give him anything.
Your Honor, I had indicated to the court, and again in my written responses, that both affidavits contain inadmissible information.
You said that there was false information, that they had said something false, but those weren't the issues in your complaint, that the summary judgments
Well,
were aimed at.
they were two separate affidavits that would otherwise have been admissible had I read them. The way that the email was sent out, as I discovered, was the email with the motion contained both affidavits. I hadn't seen anything. I was totally unprepared to argue their motion or against these affidavits. And once he already heard the motion and received the affidavits, the only thing I could do was file a motion under 1.540. Now, counsel for the appellee suggested that my motions were inappropriate because there was no final judgment. But under 1.540,
It can be directed in any order.
Correct.
It doesn't have to be
that was my understanding, so that's why I filed them.
Right.
I really,
But the judge solicited from you.
no, he indicated to me that if you have anything else you would like me to reconsider, I will.
Right.
And so I submitted my affidavit indicating that the office procedure was not followed. I was totally...
I think he was asking you about on the merits.
Well, I misunderstood.
He asked you a question, he said, what is it that you would have told me? What is it that you would have argued? I'm paraphrasing, obviously, but if this glitch had not occurred.
I would have argued that he could not enter the summary judgment considering the affidavits because the affidavits were inadmissible. Each affidavit, for a different reason, was not admissible because one contained an offer of settlement, another contained blatantly false information that they said they didn't have any information about their pensions, and it was actually published by the city that we located on the internet after the hearing.
That doesn't make it inadmissible. And that doesn't go to the that doesn't go to the issues in the case. The issues in the case were they warned you to charge this, what you think is an ungodly sum.
Yes, Your Honor.
For
review electronically their records, or even a portion of them. They didn't say you can see them or these much in this graduated scale, and my client certainly may have made an election to see the ones that were less expensive, but when you get a bill for $125,000, you have to kind of like shake your head.
What, did you negotiate for something like that?
No.
Right.
It was a letter from the city attorney saying...
You did say, you said, look, you got the first estimate.
Yes.
And you said, look, I'm not looking for paper copies.
Right.
So they went back and they revised the estimate.
Yeah, and cut it down from $125,000 to $66,000.
Right. And then did you say, well, are there classes of documents that just by their nature wouldn't have exempt material?
I did not get into any...
Because I'm sure there are such things.
I understand that, but it was a take it or leave it proposition. This is your bill. If you want to see your record...
This is the bill for the stuff that you would ask for.
Right.
That was a pretty broad request. I mean, and you initially set forth a week for the city to get together 500,000, digital pages.
Your Honor,
I mean, you were trying to move extremely fast here. And
yes.
showed up to the records office and said, where's my stuff? And then filed a letter very...
Your Honor, I would have graciously continued at their request
Right.
had they...
You were on a, I understand, I mean, it was quick, just as Judge Battleman did.
Yes.
On the flip side of it, you had a hearing coming up.
I did.
So you were in a time squeeze, I understand.
Absolutely. The time squeeze that they wouldn't agree to continue.
Well, but 119 offers under subsection 2A the ability to review it by remote electronic means.
And that's what I
And I'm
indicated.
sure you're aware of that portion of the statute, but you never asked for that because you demanded for it to appear when you got there.
Your Honor,
Why didn't you seek it that way?
I
That
asked...
would have been a lot quicker.
I was following their form as far as records that you want to see. The statute provides that they are to be observed in the office of the person in the custody of the records.
Right.
And that's why I offered.
Because the open records law vastly predates, modern technology.
That's right.
Predates the internet, predates digital. We're all sitting here with iPads. That's how we knew we got an email that said the prior case wasn't going to happen. But the current law really imposes on the public records custodian obligation to review the documents to ensure there are no exempt or confidential, statutorily prescribed confidential material.
I understand that, Your Honor.
How, they couldn't get around that. They couldn't just ignore that because you were in a hurry or didn't want to pay the money to look.
I understand that, Your Honor, and I would have certainly seen, I certainly would have seen, should have been able to see exempt record, or excuse me,
Non-exempt.
records that, non-exempt records that they didn't have to purge. Let's just say
there are records that has the record itself, the type of record itself is not exempt, but it may contain exempt information.
Yes, Your Honor.
That's what they have to look for. That's what, an email about official business, you know, see, so a lot of emails back and forth aren't public documents. You know, hey, what time is lunch? That's not a public document, even though it's a public email system. But, so they got to weed those out, right?
Understood.
You don't want to be, but also that email could say, oh, that social security number you were looking for. They got to go and read the things and weed that stuff out, even though emails themselves are not exempt.
That I understand.
So how are they possibly going to do this?
If they had provided other records that they didn't have to weed out, in other words, let's just take the emails off the chart.
All right.
Just exclude the emails. There's a lot of information that is public information that they don't have to exempt or redact. And they didn't indicate to me that they were going to have any that had no charges. That was the problem. No matter what choice my client took, she was going to get a bill for reviewing public records. And that was very clear, and we were facing a deadline.
But did you say to them, well, what about some, why don't you give me these kind of records? Because there aren't going to be any exempt material in there?
No, Your Honor, because I was still facing a deadline of another administrative hearing.
But you didn't give them the opportunity, and they did furnish you some material, correct, in response, ultimately?
No, Your Honor, because I did.
My understanding is that there were several of the numbered items that they didn't respond to furnish material to.
Perhaps they said they would have been made available, but they made nothing available.
But other than to say, I don't want paper, you didn't attempt to negotiate with the city further or cut down on your request further?
No, I did not.
It was, I'm sympathetic. I've had clients that you're meeting deadlines, you're trying to follow their wishes, you're trying to represent them the best that you can. And I definitely see that, Mr. Rock, here. That's what you were doing here. I think where the subsequent letter that you sent to the city after they didn't meet that deadline as to 1 week, it was quite confrontational, didn't offer, like, what do you have, and I'll be glad to see that. It was like, you haven't done, you have violated, you have done this, as opposed to saying, okay, can we work together? And so the city automatically went into litigation mode, I think.
Probably when you consider that there are different departments in the city, same city.
Yes, sir.
The code enforcement section was giving my client a very hard time.
Yes, sir.
They were turning down our requests for continuances.
Got it.
For that reason, I had to try to get as much as I could by way of public records law.
Right.
And they were correct that my client was not entitled to take a deposition of this police officer or code enforcement officer, even though they had indicated that they would give us a time or they would check with the code enforcement officer and see what would be made available.
Yes,
and
sir.
they get back to me and they say, we don't have to give you any discovery. I looked it up. I found out they were right. I was dealing with my denial of request for continuance and thought that if I had to prove an affirmative defense, and they knew of, and there were more than likely several cases where other people were selectively charged with violations, but that whole case Your Honor, sad to say or not sad to say, is gone. The code enforcement case is over. And we have resolved that with the city. The only thing that's left is this public records case, and I think that it shocked my client's conscience to think that, A, she could pay a fine of $6,000 or get her public records for $125,000. It just didn't make sense. And I can only say that my secretary, when she did what she did, which is why she is not my secretary any longer, received documents, sent out notices under the auspices of my name, which I knew nothing about. In fact, if one looks at the response that the city filed after I filed my motion to set aside the order, they said, well, Mr. Rock was notified, but they never said that this Janet Detro telephoned me or talked to my secretary, which they talked to my secretary. And I don't have the ability, maybe I should have had the ability to prevent my secretary from sending something out under my signature, but it was just a standard email. There wasn't any signatures involved. I usually put my initials when I sign something or do electronically send out. But I believe that the judge abused his discretion by saying, well, Mr. Rock, you're just saying that you want to redo. And I said, yes, Your Honor, I'm not prepared. I haven't seen the motion. I didn't even know there were any affidavits. I don't know how. I still haven't been able to figure out how I would be prepared if I haven't seen the motion and I haven't seen the affidavits.
Well, and that's where the judge says, well, what would you say? What would your position be in a redo? What would you have said to me at the hearing? What would your argument have been? And that comes that goes to the issue of meritorious, defense or claim that is part of the relief from 1540 relief.
Yes, Your Honor.
You're at 5 minutes left.
Thank you.
Thank you, Mr. Rock.
Your Honors, may I please the Court, Robert Eschenfelder, representing the City of Tarpon Springs. Two quick issues. The City Attorney, Mr. Daigneault, did in fact provide in his, you're correct, I can't remember which judge noted it, did provide responses to item number 10, request number 10, in his initial transmittal to Mr. Rock, otherwise conveying what the estimates were. I also would want to note that while Mr. Rock indicated to the panel that he researched and found out that a deposition was in fact, he was not in fact entitled to a deposition, and that's why he made the records request, although this element of the summary judgment is not on appeal, the court there were 2 counts to the complaint, and then the second one was the city violated due process because it wouldn't let me have a deposition. So I think it's a bit disingenuous. But otherwise, the city's position is, the law is very clear that when you get a public records request, that the city staff it's a duty, a separate duty. There's a duty obviously to produce and make it public, but there's also a duty to comb through stuff that may have confidential and or exempt information, and to make sure that that's redacted. That's part of the statutory regime that local governments have to face. And so Mr. Rock's request came in. City staff acknowledged it the very same day by email, saying we've got your request. It's big, so we're going to have to do an estimate. The affidavit of the assistant city clerk indicated it was the biggest that the city has ever seen in her knowledge in terms of its scope. And so the city did, as the record confirms, set about in a very good faith way, has to pull from different departments, what records do you have, how long is it going to take for you to get them, so on and so forth, and those were all distilled down in the city attorney's, I think it was February 2nd, message to Mr. Rock outlining what the estimate would be. And Mr. Rock then, came back and said, I'm not looking for copies, I want to come and I want you to put them all in a room, and I'm going to come and look through and I'll tell you what I want photocopied. Okay, fine, so we're going to back out the assumed 15 cents a page copy charges, and so the city attorney gave the revised estimate, and then the city took the position that we only want half of that, so it's like $32,000 is what they wanted. Is that a lot of money? Yes, it is a lot of money, but I could find no published court opinion, and certainly the statutory regime does not put a cap on things. It doesn't put what are your financial resources are on things. And in fact, we have legal counsel to a corporation who owns rental properties, and that's the dispute here, is that there were code cases against ANNEXY LLC because of the condition of their rental properties within the city. And Mr. Rock here represents them and has for a while. And so he was obviously trying to, I think he's alluded to it in his presentation, trying to make a case of selective enforcement or whatever. Fine. It's not the first time that's ever happened, and certainly this court and other appellate courts have ruled that you can pitch to a code enforcement board, selective enforcement, in that venue and see where it goes. And so he's entitled to do that, but if you want all these records and you want the city to do all this work, we have to charge you for it under the statutory regime. Getting to the second part of the appeal about whether Judge Meyer should have rescinded his summary judgment, look, the timeline of the case is important because you have the complaint is filed on February the 7th. Mr. Rock filed his motion for summary judgment even before I filed mine. He filed it on March the 9th. And so appellant claimed there are no material issues of fact. It's time for the judge to rule that this fee that was charged is unreasonable and doesn't meet the statutory regime. I didn't file my motion for summary judgment until the 12th of March. So then the notice of hearing was put out by my office on March the 16th. We didn't have the hearing until May the 25th. So I don't know what Mr. Rock's internal law office procedures are, but counsel, when you're litigating, you're supposed to apprise yourself of what's on the docket, make sure what's in your hand, and he admitted that his assistant placed this notice of hearing in his hand so that he would know what courtroom to go to. Who doesn't read the notice and make sure it's legally sufficient and so forth, especially if it didn't come out of your office? I mean, it's just something that you do. But then, so we're there, we're sitting in the Judge Meyer's chambers, and if you read the transcript of that hearing, I actually forgot that his motion was set, and so I'm making an argument, what are, and so he pointed it out to me. He's like, no, we're both here today for both of our motions. Okay, fine. But Judge Myers announced at the beginning of the hearing, I'm here on both y'all's motions, and we both argued both of our motions. And as an officer of the court, I'm telling you, he got more time than I did. Judge Myers let him go first and let him talk as much as he wanted to talk. And at no time in that process did he say, wait a minute, I'm going to be harming my clients if I proceed here today because I haven't read any of this stuff, I'm not prepared. I'm a lawyer, I would have said, okay, this is really annoying because I gave you notice, but we can't proceed. But he didn't say that. He waited to see if he won or lost, and then after he saw that he didn't prevail, then he comes in and says, I hadn't read it and so forth, and maybe he did. I'm not, disparaging, he probably didn't read it, but that is not a reason for this court to grant the relief that's requested. Otherwise, any lawyer in the world can sort of play that same tack, and if you don't prevail, then you can come back after the fact. But this gets to, I think, the central issue that Judge Northcutt, you have been asking about is what's your meritorious defense? And so Judge Myers did call everybody back to the courtroom on the 1st of June and say, okay, I'm going to consider your motions, even though Mr. Eschenfelder here is telling me I shouldn't even have to because I've already entered final judgment. So hit me with what you got. So he had, between the Judge Myers summary judgment order being docketed on the 26th, he had a month and a half to figure out, okay, well, what will I say if I get to do this over again? Do I need to take depositions? But he says his secretary did this or that. There's no affidavit from that secretary as to what she did. He says the internet got hacked and there's no technology person who comes in. So I think in this case he provides no record that there's a meritorious defense, even if we were to go back before Judge Myers. The facts remain that he asked for these 15 categories of things. We did our cost estimate. It was based upon the salary of the person who was to do it. We didn't even try to charge for things like the city attorney's help and review that we could have under the prevailing case law that's out there. So unless there are any questions, thank you very much for your time.
Your Honor, there's a difference, a big difference between not reading something that's delivered to you or just not even knowing that something has been delivered to you so you can't even read it. The latter being the case, I was completely oblivious that they had filed a motion or affidavits. As I've indicated.
Is that because of your internet or because of your staff?
Your Honor, I assumed when I found out about it at the hearing that there was some hack something had been hacked.
Well, but see,
So I
because
didn't.
what's devoid in your argument or any of the pleadings is the city's failure to comply with 1.510, at least 20 days notice of the motion and any evidence or affidavits attached there too. So you don't dispute any compliance.
Absolutely not.
Absolutely complied. So you have that for at least 20, 19, 18 days, and this isn't the only case that you have.
Your
So
Honor,
if you've got an internet problem or a staff problem, you've got staff problems with every other case. So really, whose fault is it if the staff screws up in a law firm? I was always told it was mine.
well, I'm glad that I am not to be held to that standard, especially in 40 years of practicing law. This hasn't happened to me before. But the person that was responsible for this was his legal assistant, and she was terminated that day when I got back to my office to find out that we had, the next day, I found out that we probably had in fact received it. She opened it as with the notice of hearing when she handed it to me on my way to the court. I guess what I should have suspected was that when she said, well, they're going to prepare a notice of hearing for both cases, for both hearings. Or she said, no, she said, she's going to prepare the notice. I said, fine. If they want to have it resolved, fine. And I didn't see the notice of hearing. I happened to get a copy of it on my way out the door so I'd know which courtroom to go to. And I'm thinking, gosh, I know that we sent out, I know that there was a notice of hearing sent out. Let me look at my note that was folded up in my pocket, which said...
You had a copy of their motion and their affidavits on the way to court, right?
No, sir, I did not. I did not know that there was a motion filed. I didn't even look at the notice hearing till I got to the courtroom to say, which courtroom was Judge Myers in? That,
Just for the life of me, I cannot figure out why, having tried cases for 20 years, you didn't look at Judge Myers and say, Judge, can I have a moment to review the court file since I don't have a copy? I'm just trying to figure this out, sir. I really am, because I understand and I appreciate what you're arguing, but we've all lived there. And if this was such an issue, you would not have gone forward at all. But you did. And you never let Judge Meyer know at any time that you had any issues with those affidavits.
Your Honor, I had indicated to you before, I'll do it again, I had not seen any of their motion for summary judgment that they filed. With that,
Okay, then that begs the question, why didn't you ask for time to look at it?
that is probably something that I would like to think that I should have done had the judge not say, if you have something else to say, set another hearing. But I was not in a position to argue against a motion that I had never seen, or an affidavit that I had never seen.
40 years of practice of law, and you've only had this happen to once. You are probably the luckiest lawyer I have ever heard, because in my 16 years of practicing law, it happened several times. The thing that I think that Judge Sleet's pushing towards is, if we proceed on this premise that a court or service cannot be done through the legal assistant to the attorney, and that's the excuse for it, and the attorney himself is not accepting responsibility for it, this is a very troublesome area for judges to be stepping in on here.
Your Honor, we had an office practice of making copies of motions and notices of hearings.
It comes down to the lawyer, though. The lawyer has to accept responsibility to it and dutifully and
Yes.
Tell the judge immediately when you get there what happened.
But at that time, I did not know what happened. They said there was a motion filed, and apparently they argued affidavits that I did not even know that was filed. Now, what the judge did indicate to me was that, well, you could have checked the docket. Well, I could have checked the docket to see that they were filed, and then I could have clicked in and read them. But I didn't. I only checked my internet. And there was, Usually when you get a notice on the internet, it's in bold if it's unread. If it's been opened, you don't know that it contains information that you might want to see. And that was the reason for having the paper copy made, so that that assistant could take it to that attorney and decide what to do.
Okay,
Thank you,
Mr.
Your
Rock,
Honor.
your time's up. Thank you both very much.